Good morning, everybody. But just really excited to be with you all and to talk about occupational licensing reform. We've got Emmy Williams with Georgia Justice Project, who's here to talk through some of this with us. And Emmy, I'll go ahead and turn it over to you.
Thank you, Daniela. Good morning, everyone. Happy Friday. Thank you so much for joining us this morning. I'm very excited to talk to you today about an issue that I'm very passionate about. My name is Emmy Williams, and I'm an attorney from Georgia Justice Project. I'm joined by my colleague Ann Colloton today, who will be helping me with the chat. And before we get started, I would love to ask, we're going to have a great discussion at the end. If you could hold any questions until the end, that would be fabulous. So let's go ahead and jump in. So like I said, I'm from Georgia Justice Project. Hopefully you've heard of us. We're friendly with the Metro Chamber and with Max. But in case you're not familiar, we are a legal nonprofit organization, and we provide services to people who have been involved in the criminal justice system. So among the things we do, we provide criminal defense services for cases in Fulton and DeKalb County. We also provide re-entry lawyering services. So the thing we're most known for probably is our expungement practice, which we do statewide. And then finally, we are also policy advocates on issues that affect our clients. So you can see some of the issues that we worked on. And one of the issues we are working on this year that I'm so excited to tell you about is occupational licensing. So GJP has been working on occupational licensing issues for a few years now. I personally am here on an Equal Justice Works Fellowship. That's my role at Georgia Justice Project. Here are my sponsors. Thank you, UPS and Greenberg Trareg. And what I've been doing as part of my fellowship is trying to increase access to occupational licensing for people with criminal records. So I've been representing individual clients with criminal records in licensing matters. I've also been educating the community on licensing issues, like I am here today to do. And finally, we're working on advocating for better licensing policy to open up access to licenses for people with criminal records who are qualified. So to talk to you here today, I want to just give an overview of where we're going. I'd first love to tell you a little bit about Georgia and the criminal system in Georgia and criminal records in Georgia, how we can kind of think about those in helpful context. Then I'm going to talk about why occupational licensing and reform of our licensing system in Georgia is really important. I'm going to take you through some of the barriers and the obstacles that exist in Georgia licensing law right now for people with criminal records. And I want to illustrate those problems to you with some stories from my clients, from real people that I have helped. And then finally, we'll get into the really nerdy stuff, the policy solutions. How do we fix, these hangups, these roadblocks in the licensing system for people with criminal records and allow fairer access and more people to enter licensed fields? All right, so starting off with criminal records in Georgia. So you may know, but 40% of residents in Georgia have some sort of criminal record. That's over 4.5 million people in our state. That means an arrest record or a charge or a conviction. And of those folks, almost 2 million have a misdemeanor conviction on their record. This is a huge population of people that we're talking about. And most people in the misdemeanor conviction category only have one misdemeanor conviction. When it comes to felony convictions, that number is about 600,000 people, so just over 500,000. And of those folks, very, very few of them, only 60,000 in our state have been convicted of a serious violent felony or a serious sex offense. So when we talk about people with criminal records in Georgia, most of them have very minor records, but it's also a huge population, people that you probably interact with all the time, you may employ in your work. So that's a bit about criminal records. And another unique feature to highlight about Georgia's criminal system is the amount of people that are involved in the criminal system at any one time. So I already mentioned 40% of people have a record, but Georgia is also unique in that we have a very, very large, disproportionate number of people who are on probation. So here is a chart of all 50 states and DC and their rates of people who are at any one time incarcerated or on parole or probation. And Georgia, you can see, is at the very, very top by a significant margin. And that red bar up here is all the people that are on probation currently. And we can attribute this to the fact that Georgia's probation sentences are about 2 to 3 times longer than other states. So we keep people on probation for a very long time. Actually, 40% of all probation sentences in Georgia are over 10 years. So that's another thing to keep in mind when we're talking about the criminal system and kind of this issue. Another thing that we also would be helpful to lay down as groundwork is some things that we have learned and that we know at Georgia Justice Project about people with criminal records and their employment. So the first thing to know is that people with criminal records face serious employment barriers. So the unemployment rate for people with records is 5 times higher than people who do not have a record. The other thing that we know is that jobs and employment in general are very important to avoid recidivism and rearrest, and also that we can kind of nail down a timeline for when most recidivism happens or rearrest happens. Almost all of it happens within 5 years of an arrest. So if someone's made it 5 years without being rearrested, their chances of being arrested again are almost the same as somebody who has never been arrested ever. And then the last thing to know about employees with criminal records is that studies show that they have fantastic traits. Studies show they are more motivated employees, that they stay longer with employers, and that they are promoted faster. And we might be able to attribute this to the fact that they've faced a lot of barriers, and thus they're really motivated to keep and to maintain those opportunities that they do have. And a final thing to note is that because of GJP and the work that we have been doing, in Georgia, there are very strong liability protections for employers who engage in second chance hiring of people with records. So that's just some fast facts about employment and criminal records. But I'm here today to talk to you about a specific subset of employment, and that is licensed employment. So occupational licensing. Why is this issue important? What's going wrong? How is it affecting people with criminal records in our state? So the first reason why it's important to talk about occupational licensing and licensed work is because it's a very beneficial field. So if you hold an occupational license, studies show that you have much broader employment options as a skilled employee. You enjoy higher wages and lower unemployment. You stay longer with an employer in a certain position. And you're also able to engage in entrepreneurship. So you're able to start that small business with the skills and credentials that you have. Another reason why occupational licensing is an important issue is because Georgia, as you probably know, is experiencing a lot of workforce shortages, but specifically in licensed fields. So in Georgia, 1 in every 7 jobs requires an occupational license. And a lot of the fastest growing jobs and the jobs with workforce shortages are jobs that require an occupational license. So there's some examples here in the construction field: teachers, nurses, truck drivers, and accountants. All of those are very highly in demand jobs with shortages right now. And then working in home health or as a personal care aide, those are also really fast growing professions that are highly in need. So licensed work is very important and is kind of in short supply right now. And then the last reason why licensing is important is because occupational licensing and reform of the barriers that we have will create economic development. So we know that our GDP and our employment rate are greatly reduced because of criminal record related employment barriers. And the same is true for licensing. We know that people are not being able to get licenses because of their record, and that affects our economy as a whole. All right, so that's a little bit about the background and about the context of why licensing is important. So now let's get into the state of the law in Georgia on licensing. What does it look like, and where are some areas for improvement? So One thing to know before we jump in is that there are two kind of big categories of licenses that matter here. On the left, there are the individually held occupational licenses. These are, individual professionals such as doctors or cosmetologists or dietitians, and they apply individually after they get their qualifications to a licensing board. And then on the other side, on the right side here, you have employees who work at licensed facilities. So licensed facilities include childcare, residential care, elder care, even summer camps and adoption agencies. And while employees at these facilities often don't need to have a professional license themselves, because they work at a licensed facility, they are subject to certain criminal background requirements. So we'll talk about both of these categories over this presentation. So I've mentioned that there's a lot of ways that the licensing law in Georgia is falling short, but the good news is that there are actually some strengths right now that are working well and that do strike the right balance when it comes to access for people with criminal records. So the first strength that I want to highlight for you, maybe you are not aware of this, but there's a law in Georgia that Georgia Justice Project was involved in passing in 2016 called SB 367. And this law created a right that if you are a licensing applicant with a criminal record, the licensing board can only deny you a license or revoke your license because of your record if your criminal record directly relates to the occupation that you're trying to enter, the licensed work you're trying to do. So that's the law in Georgia right now. And this law requires licensing boards, when they're examining an applicant's criminal record, to consider 6 factors. Those 6 factors are here. They're pretty common sense. So what was the criminal record that the person has and how serious is it? Is it a misdemeanor or felony? Is it violent or nonviolent? What's the relationship between the offense and the licensed occupation? So an example I always give is if someone's seeking a veterinary license, for example, a closely related offense would be animal abuse, or likewise with an accountant's license and financial fraud, something like that. The licensing board also needs to consider the age of the applicant at the time that their criminal record happened and how long it's been since their criminal record happened. The licensing board also needs to look at all the relevant circumstances, and this includes mitigating circumstances or social conditions. So the way I explain this factor is, if someone's criminal record came out of a battle with addiction, or because they had mental health struggles, or because they were homeless, the licensing board needs to consider all of those circumstances in looking at the person's record. And then finally, the licensing board needs to look at the evidence that the licensing applicant has been rehabilitated and look at their ability to do the licensed work today. So this is the law in Georgia right now, and this is a fantastic law. It's the first step into many reforms that need to be made. There's also another great law that I want to highlight for you right now, and that is a law called SB 114. And this law passed last year. Georgia Justice Project was not involved in the passage of this law, but it's fantastic regardless. So this law says that licensing boards can't deny or revoke a license just because the licensee or the applicant is on probation or parole. So this is fantastic. For many people on probation or parole, they were experiencing barriers to getting a license, and now they have a right to get a license, except in a narrow exception, narrow circumstance, which is if they are on supervision for a felony crime against a person, like battery, assault, stalking, kidnapping, those types of things, or if they're on supervision for a crime requiring them to register as a sex offender. So outside of those circumstances, someone on probation or parole has a right to get their occupational license in our state. So those are the things that are going right in Georgia right now. But as you'll see, there are a lot of ways in which Georgia is behind other states, and a lot of ways in which problems for people with criminal records in the licensing process still are experiencing trouble. So what are some of those areas of trouble, those barriers in the licensing process right now for someone with a record? So I'm going to talk about this in stages in the licensing process. So before someone applies for a license, there is a huge barrier. This is probably the biggest problem that I see in my work, which is that licensing boards don't provide clear guidance on eligibility for getting a license with a criminal record until you actually apply and they consider your criminal record. So there's no advance notice about what the licensing board considers to be an issue. And this is a problem because for many people with criminal records, if they know that their criminal record could keep them from getting a license, they're not going to seek the education and training. They're not going to invest their time and money in getting qualified for a licensed field without knowing that they will be able to achieve their license. So this deters a lot of people from licensed fields. If someone does decide to seek their education and training and they apply for a license, there's even more barriers that happen at that point. So the first thing is that once an applicant applies, they have to disclose every arrest, charge, or conviction that has ever been on their record in their life. This is true even if they have, for example, successfully gotten a pardon for their record, or if their record has been expunged by a judge. They still have to disclose every arrest, charge, or conviction. And the licensing board, in their licensing decision, will consider that entire criminal record. Even if, for example, an arrest or a charge didn't lead to a conviction, or even if those portions of a person's criminal record are decades old. So it's a lifetime review. Another issue in the licensing application is that if a licensing board reviews an applicant and they do have concerns about the applicant's criminal record, the licensing board doesn't have to give the applicant any notice that they're concerned, and they don't have to give the applicant any opportunity to explain their record to the board. So what happens most often is that licensing boards just outright deny an applicant with a criminal record if they have a concern. They don't bring the applicant in to say, you know, here's why I'm rehabilitated, or here's what happened with my record. Let me explain and try to alleviate some of your concerns. So that's a huge issue. It's not a very fair or thorough process for considering the person and their record. And then finally, this is legally very, maybe too in the weeds, but when the licensing board receives an application from someone with a criminal record, it's not clear whether the applicant themselves needs to show that they are qualified for a license, or whether the licensing board needs to show that the person is not qualified for a license. And it's not clear how much evidence is needed to make that determination. So the law is not clear. And so licensing boards are kind of free to, you know, maybe say, oh, this applicant didn't show us that they were affirmatively eligible. So that's a bit about the barriers during the licensing process. But once you've received a decision from the licensing board, if you are denied a license because of your criminal record, it is very hard to appeal without hiring a lawyer, which, as we know, can be expensive and not accessible to everyone. So once you receive that licensing decision, if you want to challenge the decision, if you think that the licensing board didn't apply the law in your case and didn't find that you were rehabilitated and they made a mistake, appealing is expensive and not accessible. And so a lot of people who are denied don't get the opportunity to do that. So those are some of the barriers for the individually held licenses where you apply to a licensing board. But if you are for example, an employee who works at a child care center or an elder care center, some type of licensed facility, you'll also encounter some barriers in the way that Georgia considers criminal records there. So let's start with long-term care facilities. If you are an employee who's wanting to work at a long-term care facility, there's a very lengthy list of disqualifying convictions. And if you have one of those convictions, you are disqualified for 10 years after you finish your sentence. And the timeline there matters a lot. So I've mentioned previously that Georgia is a huge outlier in the length of the sentences, particularly the probation sentences that we impose in our state. So if people are disqualified after they complete their sentence for 10 years, Given the lengthiness of the sentences we impose, that can lead to people being disqualified for decades, which doesn't follow the research that we know about recidivism. So that's one barrier there. And for childcare facilities, if you want to work at a childcare facility, any felony conviction that you have ever had in your life will disqualify you from working at a childcare facility. This is true unless you are able to ask a judge for permission and go through kind of an involved process to get that permission. But a lifetime ban on felony convictions is what's the case in our state today. So I've talked a little bit about these barriers, but I think it's helpful to see them in practice. So I want to tell you some stories of people who have experienced these barriers in real life. So the first client that I want to tell you about, his name is W. And W is someone I worked with. He had just graduated from his master's program in dietary sciences, and he was hoping to get his registered dietitian license. And W had a criminal record. He had 4 misdemeanor convictions, and he had 2 felony charges that had been conditionally discharged. And W's record came from a battle with addiction that he entered when he lost someone very close to him when he was young. So he struggled with alcoholism for many years, but by the time he came to see me, he had been clean for a good number of years and had moved on with his life and still had this criminal record. And W, in order to get his master's degree to be qualified to be a dietitian, he had taken out a significant amount of student loans. And so you can imagine that it was particularly devastating to him to hear that his criminal record could prevent him from getting his dietitian's license, and that he didn't have a very fair or thorough opportunity to tell the board what he'd been through and why he deserved to get his license. The good news here is that with representation, we were able to get W his license, but it was a huge worry for him that his huge investment in his education might not pay off. Another person I want to tell you about, his name is D. We'll call him D. And D came to me in the first year of the pandemic, and he had just inherited his family business, which is a funeral home. And so he needed to get his funeral home director license. And D had a criminal record as well. He'd been arrested 7 times, but all of those arrests were over 15 years old. And among those arrests, one of them had led to a misdemeanor conviction. All the other charges had been dismissed. And for D, he is an older gentleman. He experienced serious barriers in completing that application because the licensing board wanted him to disclose and get official documents for all of these cases that were over 15 years old. He was not able to navigate the court system in order to get those documents. So luckily, I was able to help him get those documents and make his case to the licensing board, and he was able to get his license. But he would not have been able to do that without assistance, even though his record was extremely minor and very old. And then the final client I want to tell you about is someone I'll call E. And E had been working in residential elder care. I believe she was a CNA for many years when she was arrested and got a first offender case, a felony charge for forgery. At the time that I met E and helped her, she was 6 years into a 19-year probation sentence for, again, the only arrest or charge that she'd ever had on her record for which she got first offender. So she was serving a very lengthy probation sentence, and she wanted to know, when will I be able to return to residential elder care, the field that I've been in for much of my adult life? And I had to tell her that under the laws in Georgia right now, she was disqualified until 2045, which doesn't even sound like a real year yet. But she was extremely discouraged by learning that she would be disqualified for 30 years from working in this field. And even though there was a process to appeal that background check result and get in front of a judge and explain, why she deserved to be able to work in this field anyway, she decided not to go through that process because it was very involved and very burdensome. So unfortunately, E was not able to return to work in this field. So those are just some stories I wanted to relate to you, but now I want to talk about what some solutions would be for these problems. What's going to make sure that people with criminal records who are qualified to do licensed work are actually able to enter these fields. And I'm going to talk about reforms for the individually held licenses, and I'm also going to talk about reforms for the licensed facility employees. So let's jump in. So for the individually held licenses, these reforms have been extremely popular in the last 5 years, and 2/3 of states in the US have implemented reforms benefiting people with criminal records. And as you'll see, there are lots of reforms. Georgia is behind. Although we do have the 2 recent reforms which are beneficial, there are a lot more reforms which can be implemented that will benefit people. So the first category of reforms is going toward promoting transparency and accessibility in the licensing system. So what does this look like? The biggest way that we can provide transparency and accessibility in the licensing system is to provide what's called a binding pre-licensing petition process. So a binding pre-licensing petition process is where a potential applicant for a license with a criminal record is able to petition the licensing board and say, I haven't gotten my education yet, I haven't gotten my training yet, but I have this criminal record that I know you might be concerned about. Can you take a look at my record and tell me whether you would license me or not? And they get a binding permanent decision from the licensing board saying, yes, we'll license you, we're not concerned about your record, or we won't license you, we have some concerns, think about pursuing something else. And many states have implemented this. I'll tell you which on the next slide, but Mississippi and North Carolina come to mind as states that have implemented this process. The next way to increase accessibility and transparency is to waive licensing fees for low-income applicants. Several states have done this as well. Another way to increase transparency is to require licensing boards to publish clear guidance about criminal records and eligibility for a license on their website. In the licensing law in our state and in many other states, there's often outdated and vague language about who's qualified for an occupational license. You may have heard of moral character or moral turpitude requirements. A lot of states have gotten rid of this vague language in their licensing code to give people a clearer idea of what licensing boards are looking for. And then finally, a lot of states have required their licensing boards to gather and report data about criminal records in their licensing application process. So the percentage of applicants with a criminal record, the percentage of licensees with a criminal record, and how many applicants with records are successful or not successful in the process. So of these, I think that the binding pre-licensing petition process and the data reporting are the most important ways that we can increase transparency in the licensing system. And I promised I'd tell you about the states that have enacted these reforms, and here they are. So we have Mississippi, we have Arkansas, Missouri, Florida, and Iowa, Tennessee, Louisiana. All of these states, and I was looking primarily at sister southern states, have implemented these types of reforms in the past 5 years. Oh, and North Carolina, Indiana, Illinois, and Kentucky. There are even more. These have been very, very popular reforms recently. The second way that we can increase fair access to licensing for people with criminal records is to limit the scope of the criminal records that are considered in the licensing process to better reflect what we know about recidivism and desistance from offending. So the first way that a lot of states have limited the records that are considered in the licensing process is to say that licensing boards can't consider records that are older than a certain amount of years. So some states have chosen 5 years, some states have chosen 3 years or 7 years, but boards have said any conviction that's older than that doesn't matter. Another way states have changed what they're doing is to say that arrest records and other non-convictions do not matter for the licensing process. So boards can consider only convictions and can't consider dismissed charges or first offender or arrests. A lot of states have also said if someone goes through the trouble of getting their criminal record expunged, that licensing boards shouldn't be able to consider that. It's no longer relevant to the licensing decision. So if someone's gotten a pardon or expunged, boards cannot consider those pardoned or expunged parts of their record. And a lot of states have also said what really matters to the licensing process are serious offenses. So this may be recent or violent misdemeanor convictions, or recent or violent felony convictions, or just felony convictions. States have narrowed it down. Instead of saying, we need to consider everything ever, we'll focus on the important and serious offenses. And then finally, for a lot of professions, a lot of states have said there should be no conviction on someone's record that is automatically disqualifying. Basically, every licensing applicant, no matter what's on their record, deserves an individual consideration of their qualifications and their eligibility. So boards can't automatically disqualify everyone who was convicted of, for example, a drug offense or a theft offense, something like that. They need to consider the individual. Of these, I think that setting a time limit for how far boards can ask about someone's history and making expungement matter are the most powerful reforms here. And here are some of the states, our sister states, that have implemented these reforms. And I neglected to mention at the beginning of the presentation, but I am going to be distributing these slides, and all of these state names are linked. So if you're interested, if you're a nerd like me, and you're interested in looking at the legislation, you can do so here. The last way that individually held licenses can be reformed for fairer access is to make the licensing process fairer or increase the due process in that system. The first way to do this would be to require a hearing. So when a board has a concern about someone's criminal record, to allow the board to bring that person in to talk about why they deserve their license and answer questions to maybe address the board's concerns. Allow that person to bring in witnesses about their rehabilitation, etc. Another way is to make the law clearer, to say it's the licensing board's job to determine that someone is not qualified or not eligible because of their criminal record, and they should meet a certain standard of evidence in order to make that determination. A lot of licensing boards, including in Georgia, Georgia's licensing boards right now are not required to issue written decisions about licensing eligibility to applicants who are denied. So if someone's denied, they deserve to know the reasons why they're denied and understand why their record was disqualifying. And then finally, I mentioned before the right to appeal. If someone has easy access to appeal a licensing denial, we'll make sure that boards' decisions about criminal records and eligibility are fair and defensible. So someone shouldn't need to hire a lawyer in order to have their right to appeal. And of these, I think that requiring a hearing is the most impactful thing because it allows the person to appear and advocate for themselves. So here are some states that have recently reformed the process of licensing to make it fairer. So again, Mississippi and North Carolina are on this list. A lot of states have taken action here. All right, so that was about our individually held occupational licenses, but I want to briefly touch on reform that would benefit employees at licensed facilities. So these reforms are not as widespread as the individually held occupational license reforms, but they are in industries that matter and that have shortages and are quickly growing. So these are childcare, elder care, and residential care industries. And they're a little bit more sensitive, right? Because these regulations exist to protect the vulnerable people here. But that doesn't mean that there is no room for making these laws better. So some reforms for these requirements first are to refine the list of disqualifying crimes. So you remember that Georgia has this new law that creates a direct relationship requirement between a criminal record and the licensed work that someone will be doing. This same idea needs to apply to our licensed facilities. So there's no reason to disqualify someone from working in a certain field if whatever is on their record doesn't relate to the licensed work that they will be doing. The second way that we can improve these licensed facility requirements is to adjust the disqualification period based on the type of offense. So right now in Georgia, whatever disqualifying offense you have on your record, you're disqualified for 10 years after sentence completion for elder care or for lifetime for childcare. But that doesn't necessarily reflect the different severities and relatedness of the individual disqualifying offense. So for example, for childcare, if you have a theft-related felony, perhaps that's less related to the practice of childcare than it is than a different kind, like a violent crime would be. That would be more related. So making sure the disqualification period reflects the severity by being a little bit lower if it's less severe, or higher if it's more severe, would be a common sense reform here. And then finally, another reform is to start running the clock immediately for the disqualification period when someone is convicted. So I mentioned before that Georgia has extremely long probation sentences, and I'm thinking specifically of elder care for this. If someone's disqualified for 10 years after their sentence is completed, that leads to, in our state with our particular probation sentences, decades of disqualification when that's not necessarily what the research supports. So someone's disqualification period should begin at conviction, not when their sentence is completed. And here are some states that we can look to when it comes to implementing these types of fairer background checks for licensed facility work. So California is an example where when you apply to work an elder care or child care facility, you're able to submit character references and a personal statement and all of that. You're not automatically denied because of what's on your record. The agency gets to consider your individual circumstances. And then in Washington, they implement a lot of rules that I think would be helpful here. So based on the severity of the disqualifying events, you're disqualified for a different number of years. Longer if it's more severe, fewer if it's not severe. And Washington begins this disqualification period when someone is convicted. I wanted to drop a brief note here about how reforms are working. So when it comes to individually held licenses and reforms that have been super widespread, a lot of states that have required their licensing boards to gather and report data about criminal records and licensing have started publishing that data. So again, this is hyperlinked if you're really interested in seeing that data. I can tell you that the reported data shows that very, very few people with criminal records are being denied in the licensing process, potentially as a result of these reforms. So the highest percentage that I could find of people with criminal records being denied a license was 4% in Illinois. So it seems to show that these reforms are being effective and getting qualified people to apply for a license and getting their license successfully. I want to throw out a couple caveats, which is the data now exists after the reforms have been passed, but there isn't as much data from before the reforms were passed. And there are also, as you're probably aware, there are barriers from getting into licensed work at other points in the process. So again, people with criminal records are more discouraged from applying for a license than people without. And there are also barriers that might be in education or training steps of the licensed work, like nursing school admissions based on your criminal record, things like that. All right, so that's all the material I had for you all. If you're interested in reading more about licensing reform, here are some interesting, again, hyperlinked, interesting reports and research about this issue that you can take a deep dive if you're interested. And here's my contact information, and I hope we have enough time left for a rousing discussion, but thank you so much for letting me present on this today. I'd love to hear from you all if any of the ideas for reform that I have resonate with you, or if you are an employer or an industry stakeholder in a licensed field is this something that you're thinking about, that you knew about, or would you like to learn more or become involved in developing solutions with us? So I'll stop talking. I'll turn the time back over to Daniela, hopefully to kick off our discussion, but I'm very thankful for the opportunity to present to you all today.
Well, thank you, Emmy. You've given us so much to think about and so many opportunities to look at reform. I think, we've certainly just got a host of options. Certainly, y'all feel free to use the Q&A feature and the chat to answer or to suggest any questions, see what other information you might need. But Emmy, I'll start off. I know you shared kind of, about there's impact in other states. We're seeing good progress, but a lot of that data is limited, especially from a pre-reform. Obviously, as we kind of start thinking about opportunities, what kinds of practices do you think that we could put in place in Georgia just to start getting a better idea of the scope of the problem? Where's the opportunities? Where are those hiccups? So we can, certainly be strategic and impactful in any reforms that we do pass.
That's such a great question, Daniela. Thank you for asking. So yeah, a lot of other states have started to report their data, and that's super useful. That data does not exist in Georgia right now. So at Georgia Justice Project, we've been working with the Secretary of State to assess whether that data about criminal records and licensing is available, whether it's able to be reported, or whether we can get a sense of how pervasive this issue is. That data has not been able to be produced in a consolidated form. So we don't have good data in Georgia right now. What I can tell you anecdotally based on the work I've been doing are two things that I have encountered with my individual clients. A lot of these barriers in the licensing process, the stories that I told provide one example, but there are many, many, many more that I could bore you with all day of people who have encountered these problems in licensing. And the other thing I can tell you is that at Georgia Justice Project, we have a records expungement practice, and at least 1 or 2 people come by per week asking for help with their record because of a licensing issue. So this is something that we see very common, and we only speak to about 4 people a week. So a quarter to 50% of the people who are coming in want to know about their eligibility for licensing or have experienced a barrier in the past. So I think it's a very widespread issue just based on the work that I've been doing. I think there's a lot of room for improvement in educating licensing boards about these issues and making the process a bit fairer. I hope that answers your question. But we're trying to get our hands on some actual data. We'll keep working on that.
Absolutely. And I think that is so important just to note that we don't have a total picture of what's going on in our state and where we could make improvements. So I think that's a huge question. I know we've got a question from Nate with Must Ministries. What is the time process from when someone starts their denial? How long does it take to kind of move through that process? And then who does the licensing board report to? And I know there's kind of every licensing board has their own rules and regulations, which I think is the really challenging part, is that they've got a lot of flexibility. So from a kind of a standard approach, there's not as much certainty, which I think is some of the issues that y'all have found for clients.
Yeah, absolutely. That's a great question. Thank you, Nate. So when someone receives a denial from the licensing board, there isn't really a clear path for appealing. So the way that you would contest a denial, sometimes you're able to reach out to the licensing board directly and ask them to reconsider. That isn't often very useful unless, again, you've hired an attorney in the process and you're able to have a bit more influence on them. But if you receive that denial and you want to appeal, you're going to have to file a writ of mandamus in Superior Court. So you're going to have to file a special kind of petition that needs to get in front of a judge. And that can take definitely a couple months, even just to get that prepared and get it filed. And once a judge receives that, they're only looking at the licensing decision for a gross abuse of discretion. So that's a way of saying that they don't have much authority to look at and re-examine what the decision that the licensing board has made. So it's not a very speedy process. It's not a very accessible process. And so, yeah, that's one of the issues, is that there's not really accountability for the licensing board's decision. And that brings me to the second part of your question, which is who do licensing boards report to? That's a great question. So 42 of the licensing boards in Georgia are housed under the Secretary of State's office. So they are administered through that office, that agency, but they don't really report to anyone. So again, they don't have any data reporting requirements. There's no requirement that they need to justify their decision to the Secretary of State or anything like that. They do have legal counsel through the Secretary of State that I think advise them on licensing issues, but there's no real review to make sure that they're making the right and fair decision in an individual case. So that's for 42 of the licensing boards. And then there's just over 10 additional licensing boards that are independent. So these are the State Bar or the Bar of Medical Examiners, the Real Estate Board. There's more examples. But those independent licensing boards have even less accountability in terms of the decisions that they're making because they are independent. So I hope that answers your question. It might be kind of a pessimistic answer, but it's there's not a lot of oversight for the licensing boards, and that's one of the issues that I think needs to be fixed.
Absolutely. And I think that's kind of some of the issues too with the data reporting is that nothing's standardized. And so it's kind of just a big hodgepodge, which is not helpful for any of us that are trying to look at this strategically. Emmy, I was wondering too, if you could share, I mean, I know from an employer perspective, we're seeing workforce shortages across the board in any area, every area, different skill levels. But I was wondering if y'all have seen like certain occupations that people are most interested in that are licensed, or kind of what does that look like? Is it just across the board, or, you know, a lot of folks really want to go into healthcare, which is one of our top fields that we're seeing kind of in demand growth and workforce shortages. But what are y'all seeing?
Yeah, that's a great question. So I'll start by saying that with the people that we serve at Georgia Justice Project, people with criminal records, they are interested in, you know, just about the full gamut of licensed professions. So I've seen everyone from funeral director to, you know, a nurse and in between. But when it comes to trends, definitely healthcare is a big trend. I would say nurses are one of the most popular professions because, you know, it's a great job. It's badly needed. It's pretty easy to get hired, and you make great money. And also, I think the nursing board is one of the more strict when it comes to criminal records and consideration there. The other professions I would say that are very popular are real estate. That's a really popular one. Insurance licensing is another popular one. Teaching, another popular one for people that I serve. And then when it comes to licensed facility work, that's actually extremely popular too. Both childcare and elder care have had a lot of clients in those fields as well. Yeah, I hope that helps answer the question. There's definitely a lot of interest across the board, but those are probably the big trends.
Yeah, absolutely. And I think healthcare it's one of those that we see. It's usually registered nurses, software developers, and tractor trailer truck drivers. So those shortages that we see across the board, you know, which is crazy. So I know, Emmy, you laid out a lot of options for reform and, you know, things that the state could do. Are there any that are kind of like a top priority for y'all that you're like, if we did this, it would just be such a huge domino effect? This is really a game changer and could kind of open, you know, so many opportunities. Kind of how do y'all think about that in terms of priorities?
Yeah, great question. I think the thing I'm most interested in that would solve the biggest problem that I'm seeing is the pre-licensing petition process. So the most widespread barrier or issue I'm seeing in licensing is that someone with a criminal record who has experienced many barriers in employment and housing and otherwise over their life, they're aware that you know, their license, if they choose to enter a license field, that could be a barrier there as well. And so without knowing for certain whether or not they're eligible to pursue a licensed career, they don't pursue it. And they just don't have that option to make that investment. So that's something that is the most common thing I hear a lot from people with criminal records. I have a dream to become a nurse, or I have a dream to, you know, work as a real estate agent. And I'm not sure if I'm going to be able, or, you know, a pharmacist or something like that. I'm not sure if I'm going to be able to pursue that because of my record. So the pre-licensing petition process would go a long way, I think, towards helping those people and also making sure that, we are allowing people with records who are qualified and motivated and driven to be entering fields confidently, getting their education, getting their training confidently, and applying for that license confidently, because that's holding a lot of people back right now. I think that would help with the workforce shortages if people had a clear answer up front about their eligibility, and also just help people pursue goals and professional development that they really want to. I could go on. I'm really passionate about a lot of these. That's the biggest one. I'll stop there.
Yeah, absolutely. And I think too, I mean, the state as a whole is emphasizing career pathways, starting in middle school. So I think if we're thinking about getting folks on a track and a pathway, I think we can all understand that we don't want to get people in more debt, especially when they have this uncertainty with a lot of questions.
Mhm.
I know, Emily, could you remind us kind of like that, pre-licensing petition process? How long could that take for someone that's thinking about that?
Mhm. Yeah, that's a great question. So, a lot of other states have said if you want to submit a pre-licensing petition process, you submit. If you pay a fee for the decision, that could be waived if you are, low income, um, and the licensing board needs to get a decision to you within 8 weeks. I think is typical. So the licensing board has some time to consider that. They can bring you in to ask questions, make sure they're making the most thorough decision. But yeah, there's kind of that, because we want people to be able to get an answer quickly. And that's another issue that I didn't really touch on here, but I think could use a lot of improvement is if you have a criminal record right now and you apply for a license, there's not a lot of expediency in that process for you. And I know there are a lot of delays with COVID generally, but it's even worse if you have a record. And unfortunately, I've had clients wait for a decision for over a year sometimes, and the law doesn't provide a way to move that process along. So I think giving licensing boards enough time to make a decision, but holding them to some sort of deadline is a good idea there, just so that people have clarity and are able to proceed with their lives and their goals.
Well, of course, I think, especially with, the shortages we're seeing, right now, and of course, in the long term as well, from a workforce perspective, I know our employers have had, job openings for months, years, consistently trying to find stuff. And as, of course, as we look to the long term, we know that, there's projected shortages in so many industries, including healthcare, that we need to continue to fill. So
Yeah.
it's not helpful for employers to be waiting a year, and it's not helpful for individuals too. So it's something that's certainly pervasive.
Mhm.
So I think Joy, I know the chat's been a little funky this morning, and if y'all have got questions, you can put in the Q&A too, but I know that Emmy has included her contact information as well as Anne. We'll make sure that's sent out too, that if you've got specific questions about how you can do this, I know that y'all have always been so helpful in figuring out what could work and how to work with employers as well as nonprofits. So certainly we'll make sure that is shared back out. But we're getting a little close on 10. Emmy, anything you want to add before we start wrapping it up?
I think I would just love to hear. I mean, I have really benefited. We've been reaching out over the past few months to a lot of workforce folks and industry folks. And if you work in a licensed field and you have something to say, if you are seeing these problems, or if you're seeing more problems, or if you feel, like you want to work on or support these solutions with us, I would love to hear from you. Please, send me an email or give us a call. I'd love to hear from y'all. I want to make sure that whatever we are proposing in terms of solutions are things that are supported and will be effective and work. So please let us know if you have any thoughts about this. And thank you very much for your interest. It's a really important issue I've been working on for 2 years now, and I'm not stopping yet. I'm hoping we'll get something done and get some good reforms so we can kind of catch up to where other states are on this issue. So thanks everyone for helping us get there.
Absolutely. And I know Anne put Emmy's information back in the chat too. We'll send that up in the follow-up email with this recording if you've got questions. But I think, Emmy, thank you so much. You've really shared so much about what other states are doing and how Georgia would certainly not be an outlier in any of these reforms. I know there's some action too with the General Assembly, so we'll keep everyone posted as how this all continues to evolve.
Absolutely. Yeah, thank you, Danielle, and thank you everyone who tuned in today. It's a real pleasure.
So I will just kind of wrap us up a little bit today. Upcoming meetings with Max. We've got Max Academy on September 13th from 10 to 3, thinking about human-centered coaching. And then next month's Max Minutes will be with Aspire Aerospace, talking about a new program that they've got to fill some workforce shortages in the aviation industry. If you've traveled this summer, I'm sure you've maybe experienced that. I know my dad's a pilot for Delta Airlines, and he's had a very busy summer too. So I think everyone's been a little tired of what summer travel has been like this year. Certainly, please participate in the Max Community Impact Survey. We want to know more about the collective impact of our workforce community, how we're all working together to support each other in our endeavors. And want to thank our anchor investors. We couldn't do any of this without our anchors that really support this work. So again, if you are working with any of these businesses or organizations, please thank them for what they do to support Max and workforce development in Metro Atlanta. That's all I've got for you guys. I hope y'all have a great Friday and a great weekend. Again, if you have any questions for Emmy or Ann with Georgia Justice Project, we'll share their contact information. But again, thanks for being with us and sharing so much great information. We're adjourned.